thanks so much for having this platform, for sharing the information that that I've put together for all of you today. I am really passionate about the notion, after, as Andrew said, having reviewed 1,500 or so complaints over the past year or 2 years now, I've become really passionate about prevention. A lot of the complaints that we receive here at the Attorney Disciplinary Board, both ones that do get opened and ones that do not get opened, are, in my opinion, completely avoidable. And so I feel as though it is a great investment of my time and yours to spend some time and some thought on how to keep them from happening. Obviously, they're a frustration for you as practitioners when you receive them and have to respond to them. I would prefer not to read 1,500 of them in 24 months. So I think that it is in everyone's interest to think about what causes a client, oftentimes a client, to complain about an attorney. And in presenting this information today, I want to get into that. But before doing that, I want to spend just a few minutes giving you an overview of what of how our disciplinary system is structured and how our office works, so that you know what it is that we do here. So the Supreme Court of Iowa is our supervisory body. They created our office through court rule, along with the Office of Professional Regulation, which is our umbrella organization, and the various subparts of that office, including bar admissions and CLE compliance and our annual client security reporting and fee payment. All of that happens through the Office of Professional Regulation. Our office, the Attorney Disciplinary Board, it exists under that umbrella, the Office of Professional Regulation. OPR, as we call it, has oversight of about 9,600 active Iowa lawyers right now, and they handle everything from the beginning of practice all the way through what many of you are hearing about right now, which is succession planning and practice wrap-up. And really their goal and their function is to provide that structure and support that all of us as practitioners out in the communities need, to be really good at our jobs and also to be accountable for compliance with the rules. The rules that govern all of our practice, of course, are the Iowa Rules of Professional Conduct, which the Supreme Court of our state adopted in 2005. Prior to that, there were ethical considerations, those ECs, and disciplinary rules, DRs, that are probably familiar to those of you who have had a little bit longer time in practice. The rules that we have in place now are modeled on and adapted from the ABA's Model Rules of Professional Conduct. They're essentially the same. There are a few slight differences here in Iowa from the model rules, but to a large extent they're the same. And in fact, we've retained the numbering of those model rules. And so you'll see model rules referred to, if you're reading disciplinary cases from other jurisdictions, you'll see model rules referred to by numbers like 1.7. Well, here in Iowa, it would be 32:1.7, which just tells us that those are located in our court rule chapter 32. But we've kept the same numbering, the language tracks pretty nicely, the comments track pretty nicely, and that allows us to reach into other jurisdictions when we're looking for precedent, if we're looking for any sort of comparisons with what other jurisdictions are doing about particular types of conduct. We're able to do that. Our disciplinary system is structured very similarly to the trial and appellate court system with which all of you are familiar. We basically have a trial court and we have an appellate process. So here at the Attorney Disciplinary Board, we function very much like a county attorney's office. We have both investigators and prosecutors in our office, and we are an advocate. We are not an advisory board. We are not we're not an independent or neutral entity. We are, in fact, advocates. And so we receive complaints from any person, oftentimes clients, sometimes opposing parties, sometimes just folks in the community or other attorneys or judges. We receive about 400, we open and investigate about 400 complaints a year. We receive somewhere in the neighborhood of 700 plus complaints each year. And each of those complaints gets reviewed in our office, and a determination is made about whether it does in fact present an ethics concern. And then once that determination is made, it's assigned a case number, and the attorney about whom the complaint was received will receive formal notice of the complaint and is required to respond. All of that happens here in our office before anything that you all might read about in any of the Friday notices of the court's opinions. All of that happens behind the scenes here. Those investigations and reviews of those complaints are confidential. If the board, which is a 12-member volunteer board, 9 lawyers and 3 non-lawyers, if the board is seeking public discipline, then the case is assigned here in our office to either internal staff counsel, prosecutors, or to outside counsel. We've got 4 internal staff prosecutors, and they handle the bulk of our cases, but periodically we refer a case out to an outside prosecutor. We try our cases to our trial court, which is a panel of the Grievance Commission, and the Grievance Commission is a pool of attorneys and lay people that sits in panels of 5 to hear these cases. And the Grievance Commission panel then makes they hear the presentation of evidence on behalf of both sides, and then they make written ruling, which includes their findings of fact, their conclusions regarding rule violations, and a recommendation to the Supreme Court for a sanction. All formal discipline, all public discipline comes from our Supreme Court in the form of an order. So there will either be an order among those Friday opinions, or there will be an order imposing a public reprimand on a lawyer. And there's a little bit of a streamlined process for the imposition of public reprimands if the attorney does not take exception to the board's proposal that the attorney be publicly reprimanded. There's a little bit of a streamlined process, but all of that discipline comes in the form of an order. And of course, you can always search for an attorney's public disciplinary history through the Iowa Court Commission's website. The revamp of the Iowa Supreme Court's website includes some slightly quicker ways to get to those public disciplinary histories than was the case in the past, in order to make that information available more readily to the public as well. So I said before, we open about 400 complaints a year. That's held steady for a while. We opened 390 in 2015. We opened 425-ish in 2016. I am also given discretion under the court rules as the Assistant Director for Attorney Discipline to decline to open certain complaints. And some of those are complaints that, for one reason or another, simply don't merit the investigative time. They may be complaints that fall outside the jurisdiction of the board for various reasons. Perhaps they're an allegation of a violation of someone's constitutional or civil rights. They may be an allegation that would be better resolved in the trial court or appellate court system, perhaps a claim of ineffective assistance of counsel, for example. Simple fee disputes we typically don't handle. So we do receive a fair number of complaints, more than we open this year anyway, of things that simply don't warrant investigation. Sometimes there are duplicative complaints. They may be complaints that just don't make sense for one reason or another. And so I will decline to open those. Every complainant, whether we open a complaint or not, of course, gets informed of what we're going to do with the complaint, whether we're investigating it or not. If there's a complaint about a respondent that we don't open, that respondent attorney does not get notice. So there are inevitably complaints that this office has received about which an attorney will never know, and that's just the nature of our day-to-day work here. The rules the rules basically tell us that a complaint that is not investigated is not deemed a complaint, and so the attorney is not given notice of it. As of yesterday, we had opened here at the board 308 complaints for investigation. We had closed, completely resolved, 360. We had reached board disposition on 375 matters. Now, some of those, that number is larger than the number of matters that have been closed because some of those board dispositions require additional action to be taken either by our office or by the court. We've started tracking for the first time in our history public inquiries, contacts from the public about ethics concerns that they have. And I think it's helpful for us to know how many people are reaching out to express concerns about attorneys. It's also helpful for me in thinking about prevention. What is it that we're hearing people call to complain about? Even if they don't send in a complaint, what are they asking us about? What are they worried about? And then finally, we've received thus far this year 414 complaints that were not opened pursuant to the rule that allows me to not open those complaints. And those I think are really informative too, because those are complaints where somebody felt strongly enough to do the paperwork to send in a complaint about a lawyer. And that tells me something. That's not just, you know, grumbling about the lawyer to a family member or even putting a Facebook post up there about how much somebody didn't like their lawyer. But those are people who found our form or wrote a letter and submitted a complaint to our office because they were that concerned about the conduct of an attorney. So I think it's important for us to glean from those whatever we can about the types of concerns that people raise about their lawyers when they feel frustrated with or angry with their attorney. One of the other things that I think is important for all of you as practitioners to know is that we are finally conquering our backlog, and that's really important to me. I think that's something that I feel I need to be able to promise to my practice colleagues, that we will do everything we can to get these complaints opened and investigated and processed to disposition as quickly as we can. Most of our complaints, I'll share more about this in a moment, but most of our complaints are resolved with a dismissal. And nobody likes to be the subject of a complaint, and nobody likes to have to worry about a complaint or inform their malpractice carrier about a complaint. And so one of the things that I feel really strongly about doing is getting those off of all of your plates as practitioners as quickly as I can. And then obviously if there's merit to the complaint, if it's something on which we should take action, then the protection of the public demands that we act quickly. So there are really good reasons for us to move these along more rapidly. And you'll see in 2015 and 2016 on this bar graph that we were opening more than we were closing each of those years. Well, we didn't have closure numbers in 2015, but we were opening more than we were disposing of at the board level in each of those years, and by quite a lot. And that contributed to a pretty hefty backlog. And we're eating away at that in 2017. We're making really significant headway. I think we're going to be up above probably 425 board dispositions this year and probably just over 400 file closures. So those are going to be great numbers to be able to report to all of you practitioners and to report to the court. The other thing that's important to know is that the effect of that rule that allows me to decline to open complaints. And what this graph shows you is that up to 2011, when every complaint that was received about an attorney had to be investigated, the numbers were, I mean, those were some pretty significant numbers. After 2011, with the adoption of the rule that gave the director of this office the discretion to decline to open certain complaints, those numbers, the numbers of complaints being actually opened and investigated dropped off. My predecessor, Charlie Harrington, and I have both talked quite a lot about the impact of that rule. And the right side of this graph really mirrors some national trends that I think we've been seeing in attorney discipline. We're seeing a lot of complaints come in the door as our public becomes a little bit more savvy and familiar with our process. But the ones that require investigation, the ones that include allegations that are serious enough or that fall within our jurisdiction to deal with, are actually dropping off. And that's what we've been seeing nationally. I predict that we'll end the year with about 335 or so investigations undertaken. And I'm pleased with that number, and I'm glad to see that that's mirroring the national trend. Hopefully that'll continue, and we'll hover right around 300 in coming years, and we'll be able to finish up our backlog and make sure that all of the cases that come in get investigated very quickly. In terms of dispositions, I alluded to this a moment ago. In 2016, so this is the full year's data for 2016, the disposition of over half of our cases was a dismissal. So the case was investigated, the allegations were determined not to have merit, or at least not to be provable to our standard, our burden of proof, which is one that you probably didn't hear about in law school. It's a convincing preponderance of the evidence. Nobody really taught us that when we were all in law school learning about beyond a reasonable doubt and clear and convincing and preponderance, but we're somewhere in between clear and convincing and preponderance for a convincing preponderance. So 50+% were resolved in 2016 by dismissal. Another 15 or so percent were resolved with a private admonition. And then the remainder of the cases resulted in either the imposition of a public reprimand or prosecution to suspension or disbarment. We also handle in our office applications for reinstatement from suspension, trusteeships in cases where attorneys have either died, been disciplined, disappeared from practice, or become disabled. So we handle those as well. And then a number of cases that were closed without adjudication, typically because a suspension or a disbarment was imposed for that lawyer, and a determination was made to close those cases without adjudication against the time when that attorney might ask to come back in. I looked at dispositions as of yesterday, and we had completely closed 360 cases as of yesterday. Over 60% of those had resulted in a dismissal. We're still right around that 15 to 16% for private admonitions, and then a slightly smaller percentage of those cases have moved forward through public reprimand or a suspension or disbarment. That number is always going to be a little bit strange. Sometimes a prosecution in our office might consist of 10 or 15 underlying complaints. Sometimes it might consist of one underlying complaint. So they're made up very differently, and I think that number is always going to be a little bit in flux. The other number that I think is important to note here is, and we had actually none in 2016. We've talked, though, a lot in disciplinary groups. We have a national disciplinary organization called the National Organization of Bar Counsel. We talk a lot about the importance of alternative dispositions of cases, and we do have the authority here in Iowa under one of our governing rules to defer discipline in certain instances. We're limited, though, by some constraints that the court has placed on the availability of that option. And so we're talking a lot about whether those constraints might be lifted and the board might be given a little bit more discretion to impose deferrals of discipline, or basically sort of almost like an alternate sanction to just take some of those cases off of the disciplinary path and instead place the board in a position of monitoring, frequently for attorneys who are struggling with substance abuse or alcohol problems. That may be a better disposition of the case than the imposition, for example, of a public reprimand and no monitoring for that lawyer. So we're talking about that. I think that's something that we're going to continue to reinforce for the court, that we would like that to be more widely available in appropriate instances. When I think about what I read in these complaints, these 1,500 or so complaints that I've read over the past 2 years, it's probably no surprise to any of you that the most frequent allegation that we see is of neglect or incompetence. And it comes in lots of different ways. It'll be an allegation of ineffective assistance of counsel paired with lack of communication. Typically those do get opened because the allegation of lack of communication is one that is a clear violation of, or would be a clear violation of the ethics rules. Mishandling of money or other property comes up from time to time. Dishonesty, misrepresentation, fraud, deceit. My lawyer has lied to me. those types of allegations come up in about a quarter of complaints that come in the door. Various types of litigation misconduct are reasonably frequent in the allegations that we see. One of the things that I notice is that conflict of interest allegations are made pretty often, but they are oftentimes based on a misunderstanding among the general public of what constitutes a conflict of interest. And so oftentimes I'll write a complainant a letter indicating that the thing that they're claiming is a conflict of interest really doesn't amount to a conflict of interest under our rules. The fact that, for example, a prosecutor and defense counsel know each other and shook hands at the end of trial is not a conflict of interest. That's just being polite in the courtroom. But that will often lead a client to believe that somehow there's collusion between those two, and oftentimes that comes in the form of a conflict of interest complaint. So I mentioned before that we're working away at we're pecking away at our backlog, and we've done a really good job of reducing that during this calendar year. My goal at the beginning of calendar 2017 was to make sure that we had one complaint in, one complaint out, and we're well ahead of that. We're also working on reducing our investigative times and on the delay time that we have before we can get a case prosecuted to the Grievance Commission. We're still struggling with the challenges. Of course, we only have 4 prosecutors. We have a lot of calendars to coordinate in order to get a case tried. When you've got a panel of 5 folks, that's a little bit of a challenge. But we're working on getting those cases heard more quickly. Again, because our protection of the public function really is, depends on getting those cases heard and up to the Supreme Court for consideration as fast as possible. We've also adopted a case management system. It's been in place for about 18 months, and that has dramatically sped up our document preparation and our correspondence here in the office, not to mention just keeping track of exactly where every case is in the process at any given moment. Those of you who are practitioners or who are defense counsel dealing with these complaints or dealing with colleagues with these complaints, people, a respondent can call in, or respondent's counsel can call in and ask where a case is at any given moment, and we can tell them exactly where it is in our process. And that's an ability we just haven't had before, so that's been very valuable to us. And then finally, there are a couple of new things that I think are coming along in the area of attorney discipline that are really worth our consideration, and I'm trying to talk them up to the court as often as I can, and share with practitioners why I think they're so valuable. And really, the overall theme for these is prevention. We are using more prevention strategies. One of them is, of course, CLE and the education of our bar members. But we're also trying to do other things to prevent complaints coming in the door. One approach that has shown signs of pretty great success in other jurisdictions is what is called proactive management-based regulation. It's an optional kind of practice enhancement in the state of Colorado. It is a mandatory program for practitioners in Illinois who don't have malpractice coverage, and essentially it's an all-encompassing practice review where an attorney looks at every aspect of their office management practice and makes a determination about whether they are doing everything they can to prevent ethics complaints from happening about their practice. And I think you'll be hearing more about it here in our state because our court certainly seems as though they're interested in it. I think it's taking off nationally, and folks in disciplinary circles are really excited about it. As I mentioned before, we're also trying to expand these deferral and diversion agreements, and maybe having some probationary type monitoring in place for attorneys that have struggled with various types of addiction issues to give them a chance to demonstrate to the court that they're doing well and that they're complying with all of the requirements that might be agreed to for them to maintain practice. We're also talking about Trust Account School, which I think would be really valuable for practitioners, both new attorneys, attorneys maybe who are struggling with trust accounting and have come to the attention of the disciplinary system, and then also attorneys who are making a transition from government or firm practice out into a practice setting where they need to have direct control of a trust account. So I think that's something that the law schools are interested in partnering with us on, and you'll be hearing more about that as well. We're also working, and I'll talk about this at the end of my presentation, but we're also working with the Iowa Lawyer Assistance Program to get creative, particularly in the area of these deferral and diversion agreements, but also in other ways to reach out to attorneys who may be struggling personally, to make sure that they understand that the Lawyer Assistance Program is available to them, and that the Lawyer Assistance Program does not funnel complaints or notices or stories about attorneys to our office, but really exists as an independent resource for lawyers who need to work on their well-being and make sure that they're doing all right. The Lawyer Assistance Program here in Iowa deals with substance abuse and alcohol problems, but also with mental health challenges for lawyers. So it's a really valuable resource, and we're doing what we can to partner with them. One thing we're doing recently is notifying respondent attorneys who are receiving complaints from our office of the availability of that program, even to deal with the situational stress of just having a disciplinary complaint that they need to respond to. So the other thing that Andrew asked me to do with this presentation, and I've been trying to focus on as I've been out talking to practitioners this year, is to think a little bit about what you can do to avoid the ethics complaints that we see on a day-to-day basis. I'm looking here at my desk, and I've got a stack of about 2 inches worth of ethics complaints, which represent yesterday and today's mail. I haven't quite gotten through them yet, so there are probably 15 of them there, and they'll take me the better part of this afternoon to review and respond to. So it's in my interest and all of your interests to avoid them. And really, I think it boils down to 2, not secrets, 2 approaches, two important things that each of you should be thinking about at all times during your day-to-day practice. And I'll spend a couple minutes talking about the one of them that I think has led to a lot of complaints in the past few years, certainly since I've been here, referrals from the Client Security Commission, and that is managing client money. And then the second one is managing your client's expectations. As far as the complaints that we get about attorneys' handling of money, one, of course, there are some of them that simply allege that an attorney has stolen money, has taken their client's money. But more often than that, we get complaints that allege that an attorney has lost track of their client's money. And our court has been very clear about the importance of keeping track of your client's money, managing the business side of your law practice, and our court's gone as far as saying that this requires the same attention to detail as your entire practice of law. But we all know that that's the least exciting side, at least for most of us, of our practice. Checking up on our trust accounting, making sure that we're doing all of our billing and accounting on a timely way, sending out notices to clients that we are withdrawing funds from the trust account. None of that's fun, but it is incredibly necessary. And that is because every trust account that you have, all of those bank trust accounts that each of us maintain as Iowa lawyers, create a fiduciary responsibility to the client. And that's because that money belongs to the client. It doesn't belong to you as the practitioner. Iowa Court Rule 45.7 deals with advance fee and expense payments and tells us that every penny belonging to a client must be placed in a trust account. And that includes any advance that the client gives you for costs or expenses, and excludes only general retainer fees. And I can say with some confidence that the number of Iowa lawyers who actually accept general retainer fees is, if there are any, they're there are, there are probably 10 of them. A general retainer fee is simply a payment, an ongoing payment to a lawyer for that lawyer's availability. And we don't really do that here. So pretty much any client money that comes in the door needs to go into a trust account. And the most important thing to keep in mind is that that money belongs to the client unless you do something. It continues to belong to the client until you either earn it or you disperse it under the direction of your client and pursuant to some sort of agreement with your client. Every client must be given a notice and an accounting, basically just a statement of how much is left whenever there is a withdrawal of their money from the trust account for fees or expenses. And that notice and accounting has to go to the client no later than the date on which you take that money out. And then any money that's left when if a fee isn't earned or an expense isn't incurred, any money that's left in the name of that client needs to go back to the client. And once a month, every Iowa lawyer who maintains a trust account must cross-check their client sub-accounts. So you add up all of the dollars you have for client A, client B, client C, client D. You have to add all those up and then compare that total with your bank statement and with your check register. And that's the three-way reconciliation that's required by our court rules. That's really it when it comes to taking good care of your client's money. Also, probably more challenging and certainly more interesting to me these days is the issue of managing your client's expectations for the work that you're going to be doing for them. And like I said at the beginning of this talk, 1,500 complaints in, I can say with some confidence that most, by a long shot of those, dealt with a client not getting what they expected from the relationship that they have with their lawyer. And when you think about that, it makes a lot of sense because these complaints look like the type of frustration that anybody would have if they expected to talk to their lawyer more, or they expected they weren't going to lose their case, or they expected their case was going to go to trial and that they would have a judge attending to their every word and hearing their story. Or they expected that they would get the same outcome, the same child support, the same prison term, the same jail sentence as their friend or their neighbor, or their acquaintance, or someone they met on Facebook got. I get a lot of complaints from people who expected they weren't going to go to prison. I get a lot of complaints from people who expected they were going to get another chance from the court. We get a lot of complaints in this office from people who wanted to go down fighting or to take their case to trial. And then finally, the complaint that it's kind of hard to categorize, but we get a lot of complaints from folks who expected that they wouldn't look bad to anyone else. They're embarrassed, and the outcome of their experience in the legal system has caused them to feel somehow embarrassed or ashamed, and they project that onto their lawyer. And I've given a lot of thought to why attorneys may struggle to manage their clients' expectations at the outset of the attorney-client relationship. And I think there are a number of reasons why we're not necessarily very good at this. One, and a very obvious one, is we need the business. We're looking for an opportunity to bring a new client into our office. We need to get paid. And so we may, in those initial interactions with a potential client, we may not make it entirely clear to that client that we're not a magician. We may truly want to help. The client comes in and they tell us a story and we're very frustrated or angry about some injustice that may be happening to them, and we want to help them out. Another reason that we struggle sometimes as practitioners to manage our clients' expectations at the outset is that we don't know everything yet. I can give you an example of one complaint that we investigated here in our office where the client claimed that he went in and talked to his attorney about his custody case, and she assured him that this case was going to be a slam dunk. I mean, it was a winner. And he hired her and provided her with a retainer fee, and I think felt pretty confident that he was going to win. Unfortunately, though, the attorney didn't know that that client had a domestic abuse history with that same, the mother of his child, and an extensive criminal history about which he hadn't told her. And so in that initial conversation, when everybody was just getting to know each other, the attorney didn't have all the facts, and maybe persuaded by what seemed to be a really nice, friendly client, didn't recognize or realize that this was going to be an uphill battle in this case. And unfortunately, the client walked away from that initial meeting feeling confident. The attorney learned a lot about that client after the fact that caused the attorney to feel less confident, and suddenly the attorney wasn't on that client's side anymore. We also really, I think, struggle, all of us as practitioners, to make sure that our clients feel reassured that we've got this taken care of. We're on it. We've got this covered for them. And so we may allow a client to believe that things are going to go really well because we've got it all under control. And then when it falls outside of our control, they're frustrated with us. So there are a lot of reasons why we're not so great at managing these expectations right out of the gate. I think it's important to think then about what it is that we're going to be telling our clients as the case goes forward. And I've asked groups of attorneys, groups of practitioners in CLE meetings, how many of you have delivered bad news to a client within the past week? And typically in a room full of kind of mixed practitioners, folks who do all kinds of different types of practice, 75% of the hands go up. So I think it's important for us to recognize that we spend a lot of time giving our clients unwelcome news about their future, about the outcome of their case, and by extension, their future. Oftentimes with our clients, that'll mean a child custody determination that they don't like, time in jail or prison that they don't want, a loss of money that they don't want or expect, that feeling of embarrassment to which I referred before, or some uncompensated wrong. I got hurt and I didn't get paid for it. I was wronged in some way, and there's no redress for this. And that is bad news to a client. So we traffic in bad news, and our clients often don't expect to hear that bad news. They thought that you were going to take care of this for them. And because they don't expect to have received bad news from you, they interpret that as a sign that you're working for the other side, or you're not competent, or you've neglected their case. Or if you had just done what they asked you to do, file these motions, call these witnesses, depose these people, obtain this evidence, they wouldn't have this bad news. And that's a real struggle for us. Our clients are hopeful that we're going to take care of things for them. So as a starting point, I encourage all of you to think of these things at the beginning of your relationship, and then throughout your relationship with your clients. Remind your client that you are on their side and that you love to win, but you will always tell them the truth. That you're not going to lie to them, you're not going to look at this case through rose-colored glasses, you're going to be frank and honest with them at all times. But with that assurance that you're going to be frank and honest with them, you also need to say, but I am on your side, I am your advocate, and I really want to win. I went to law school because I want to win. So those two things are incredibly helpful to clients, and really reassuring to them that even when it looks like you're being friendly with the other side and you've shaken hands at the end of a hearing, that you're not selling them out. The other thing that I think is really interesting to think about is the framework within which we share bad news with our clients. And that bad news could happen at the outset of a case where we say, you know what, I just don't think you've got a case here. Or it could happen at any time during the progress of a case when maybe you get an adverse ruling or some final disposition of the case that's unwelcome. I think it's important for us to think about how we share that information with our clients, because their reaction to it drives some of them to feel unhappy about the interaction with you as a practitioner, and drives some of them to file disciplinary ethics complaints because their expectations were violated and they don't know what else to do with that bad news. There's an extensive research literature out there in the field of medicine for to help practitioners of medicine break bad news to their clients effectively. And there are different ways of doing it. This one kind of grabbed my attention because I think it's something that we all can relate to. This is called the Spikes protocol. And one of the things that I really love about this approach to breaking bad news to a client is that, or a patient in this case, but a client for all of us, is that we don't do this very well, but doctors are encouraged to ask the patient, or in our case, the client, what they know about their current situation. And it's such an interesting thing to say to somebody, what do you know about your current legal predicament? Tell me what you know about this. What's your feeling about where you are in this case, or what things might happen in this case? And imagine doing that in a child custody case or in a criminal defense case, which are, as you might expect, our two most common complaint areas. You know, elicit from your client what they already know. And with that, you're also going to hear their fears. And with that, you're also going to hear something about their expectations of you. And you'll see on the left side of your screen there, with respect to patients, sometimes patients will face a doctor with unrealistic expectations. They told me that you can work miracles. Well, what are you really hearing from that patient, or in our cases, that client? You're hearing their fears and their concerns and their emotions about their current situation. And then this proposed approach to breaking bad news then encourages the practitioner to ask the client if he or she is ready to hear the details from the professional. All right, you've told me what you think about your situation and about your symptoms and about your medical condition. Now let me tell you, if you're ready, what I think about that. And that's such a great approach to sharing our expertise. We as practitioners have gone to law school, we've studied a whole bunch of things, but I would be willing to bet that many of you, and I certainly would include myself among this group, we start off conversations with clients with all of our expertise and none of their knowledge and expectations and their worries and their fears. You know, if I was having a conversation with a client in my practice, which was primarily family law practice, about their custody case, I was pretty busy jumping into what I knew about similar custody cases and what I knew about, you know, how a judge might handle this or that fact pattern. But I didn't ask my clients, tell me what you know about custody cases, about what facts go into your current situation here that might be important to a judge. One of the questions that I think is really valuable to ask, and I learned as my practice continued to start asking this question in almost every meeting with clients, what might I hear about you from the other side, even if it's not true, what might I hear about you? And think about that you're inviting them to express what they're worried someone else might say about them. And that gives you so much information about their fears about the case and their expectations of what you might be able to gloss over for them. So it's really valuable. So this Spikes protocol is one approach. There's also an ABCDE model that some doctors use, where again you're sort of setting up the therapeutic relationship with the client and inviting them to be ready for the communication that you're going to have with them. And then each of these includes a requirement that the practitioner encourage the patient, the client, to share their emotions. How is all this making you feel? Are you looks like somebody else may have just lost sound too. Andrew, can you hear me? Andrew, are you hearing me?
Yeah, I'm hopping
Hello?
on. Tara, can you hear me?
Yeah, I can hear you.
So we lost you for
Is there
maybe
something?
30 seconds there, and we just got you back.
Okay. Okay. Yeah, that was strange. I just had an audio recording reading to me. But, well, you probably didn't hear me talking about this ABCD model. This is just an alternate way of approaching these interactions with clients. Um, each of these approaches really encourages the practitioner to think about the client's emotional reaction to the information that you're sharing with them. And I think that's a really important piece of advice for practitioners who are going to be dealing with unwelcome news with their clients. And each of these models also recommends, maybe more than recommends, strongly recommends, that the practitioner stop every once in a while and be quiet. And think about this in times in your life when maybe you've heard some unwelcome news. Your brain needs a moment to catch up with it. And so I can imagine, again, those client meetings where you're talking over the challenges that you see with this client's unique set of facts and how difficult it might be to try this case given these facts. Maybe it's a criminal case and you realize that the evidence is pretty substantial against your client. It's important at that moment to recognize that your client may need time to catch up. Your brain works fast. You do a lot of this work. You've handled lots of these cases. And so your client may just need a moment. And one of the scholarly articles that I read about this suggested to stop talking far beyond when you feel uncomfortable. And again, we lawyers are pretty used to filling silences, but let that silence persist, even beyond where you feel comfortable. And then when you just finally can't handle it anymore, encourage the client to ask you some questions. This is a lot to digest. I've just given you a lot of information. What can I answer for you? What questions can I answer for you to help you with this? And again, think of what that might mean in terms of your client being able to process and come to accept your great advice about their difficult situation. So boiling it down, I think, again, kind of looking at the managing client expectations literature and looking at this medical literature, I kind of distilled this into 5 points that really seem to be the core of managing client expectations. And these arise so frequently in complaints that I think if attorneys out there in Iowa started doing these things, we would see our number of complaints coming in the door reduced by half. Talk to your client about what kind of communication they can expect from you and how often they're going to hear from you, and then do it. I know that's really hard. We get complaints constantly that an attorney promised to write to or often visit a client, typically in jail or prison, and then didn't do it. And then the attorney's response is often, yes, I promised that I would do that, but I got really busy. Well, you got really busy and now you just had to deal with a disciplinary complaint that could have been avoided by following through on that initial commitment. And kind of the corollary of that is don't make that promise unless you can do it. We tend, again, to be optimistic and we want our clients to be pleased with us, and we say, hey, I'm going to come see you next week in jail, and then we get busy and that falls to the bottom of the list. But that client is sitting there in jail stewing about why you lied to them. So I think that's really important. Having a clear, detailed written fee agreement is so important. And in that fee agreement, you can spend some time explaining to the client what he or she is buying from you. What are they getting from you? They're getting your loyalty. They're getting your attention. They're getting your expertise. How much are they going to pay for it? And how are you going to take that money from them? Make that all very clear. Talk to your clients about what your boundaries are. And again, I see a lot of complaints come in about attorneys that a client just simply didn't feel were the attorneys that didn't seem available to them. Sometimes those complaints are really outrageous. My attorney took a vacation. Well, attorneys should be able to take vacations. And in fact, I've written back to complainants to say exactly that an attorney who's rested and has had a vacation is probably a much more effective advocate for you than an attorney who is burnt out and tired and hasn't gotten away from the office in 52 weeks. One way to do this that's really simple is to give your client a notebook in which to record their thoughts or their questions or their concerns between any meetings that you have. And then when the client calls you unexpectedly on a Friday afternoon at 4:30 with a million questions that you are simply not equipped to answer right then, you say to that client, I'm glad to hear from you. I'd like you to write those questions down in the notebook that I gave you. And let's set an appointment for next week and you can come in and tell me about them. It's a reasonable approach to an expectation that that client has that you're going to take care of their problems right then. Talk to your clients regularly about what their goals are and revise those goals together. Say, hey, what's your goal here? You're being prosecuted for a criminal charge. What's your goal? And their goal may be something that's unattainable. It may be something that's attainable. But unless you ask that question, you're not going to know. And wrapped up in those goals are also your client's expectations of you. And so if you validate those goals, hey, I know you'd like to stay out of prison. I'd like to keep you out of prison. And that's a valid and reasonable goal. But we've got some facts that are going to make that really hard to do. Here's why I think those facts might make that hard to do. And then talk to your client again and again about what those goals are. And anytime you do attain those goals, any goals that maybe you've set as goals along the way, note those for the client. Send them a letter. I was really pleased that we got a good temporary matters order in your child custody and divorce case. I think that was something that we both talked about as a goal, and we've now met that goal. The next steps we need to take are the following, and then explain that for them. And then, like I said before, lay very careful groundwork with your client for any bad news that you do have to share, and refer back to those medical models. I encourage all of you to Google those, spend a little bit of time poking around in that literature. I promise you that'll be 30 minutes well spent. It'll really shape the way you have those interactions with your clients going forward, because it's so logical and it makes such great sense to approach those interactions in that way. And I don't think that it's going to cause very many of you to have to adopt a completely new approach to talking to clients. It's just going to remind you that a couple times during those conversations, you need to be quiet and you need to ask questions and you need to let your client share with you what they expect of you. And then together you can reset their goals in light of those expectations and what you know to be the facts of their case. In every interaction with clients, you need to think about 3 key issues that you should be talking about pretty much constantly. The prospects for success, and that's on the big and small level. Success of a motion that's pending, success of, on the entire case, what it's going to cost, being very frank with clients about what's going to cause costs to go up, and then timing. And be realistic about your court's caseload and the case processing times that clients become very attached to this could take 6 to 12 months. Well, believe me, they're thinking that it's going to take 6. So think about that. Really, this boils down to one, I think, very simple piece of advice, although it's harder to implement, but really, I think that we manage our clients' expectations best if we meet them. And that doesn't mean that you have to kill yourself trying to meet them. It doesn't mean that you have to give absolutely every moment of every day to your clients' unrealistic demands and expectations of you. It means you have to think about what your client expects and help them to change their expectations where needed, so that what happens in your case is what they see coming. And I think that's incredibly important and valuable for clients in the types of cases that give rise to the largest number of complaints in our office. Finally, I always end every talk by reminding all of you of the importance of looking out for each other and looking out for yourselves, for your own well-being. Lawyers experience drug and alcohol abuse at rates much higher than the general population, experience mental health challenges at rates far beyond the general population. We've all seen studies that document this. It is frightening. We are not well as a profession, and we are unfortunately going to continue to feel the effects of that level of illness in our profession, in our disciplinary settings, in our interactions with each other on a day-to-day basis. Certainly the number of disciplinary cases that I see that involve substance abuse or mental health challenges is really significant. So I encourage all of you to think about what you're doing to be well. Think about where your friends and colleagues might be struggling to be well, and encourage all of you to help yourselves and help your friends to get assistance if that's needed. The Lawyer Assistance Program is always available. Hugh Grady is the current director of that program. He does not funnel information to me. I assure you that I don't know who he's working with, and he is willing to go to great lengths, drive across the state, do just about anything to look out for practitioners who need his assistance. So I encourage you to reach out on behalf of your friends and colleagues if they're struggling. You know, make sure that you reach out and encourage them to reach out. He's a great resource. And then finally, this is my contact information. It'll be in the slides that Andrew will send to you. I encourage you to call anytime. I'm happy to talk with you. I cannot give ethics advice. I'll direct you if you call and ask for ethics advice. I'll probably direct you to the Ethics Committee of the State Bar Association. But I'm happy to talk to you about our process, about philosophical ideas for being better as a profession. And you know, if you call with any sort of ethics concern, I can often kind of put you onto the right general area of the ethics rules to consult. You know, I'm happy to reach out. I want to be as transparent as possible. Our attorney disciplinary board is, as I said before, a creature of court rule, but we recognize that our responsibility is jointly to you as practitioners and to the public, to make sure that the public is protected as well. And we're doing everything we can to make sure that all of you know what's going on in our office and that we're taking seriously the complaints that we investigate, but we're also trying to get them done and resolved as quickly as we can. So I appreciate the chance to talk with all of you. Andrew